Hello, everyone, and welcome to the Commercial Awareness Compass, your weekly guide to developing commercial insight that goes beyond just headlines. Each week, we take one major story and break it down to help you progress through three levels: beginner, intermediate, and advanced commercial awareness. Whether you're just starting out or already have some understanding, this program is here to help you think like a commercial lawyer. By the end of today's session, you'll have practical insights that you can use in applications and interviews. So today's episode looks at one of the most dynamic and challenging areas of law right now. It's how intellectual property laws are being pushed and reshaped by the rapid growth of AI. As AI tools are adopted across creative, scientific, and commercial industries, questions about copyright, ownership, and liability are creating new legal frontiers for both clients and lawyers. So we've got a lot to get into today. So my name is Daniel Shepherd. I'm a law conversion student and a future trainee solicitor. Today I'm joined by Brendan. Welcome to the podcast today, Brendan. How are we doing?
Cheers, Dan. Thanks for having me again. I know we've done a number of pods, so thank you again for having me. It's great to be back on with yourself on All About Law's Commercial Awareness Compass program. And thank you for those tuning back in again to listen, both myself and Dan. It's a pleasure to have you here today. For those who have not listened beforehand, my name is Brendan Collar. I'm a commercial legal counsel for TikTok. Recently relocated from London to Dubai. I've been here, goodness me, about 2 months or so now. So yeah, it's gone quite quickly. But yeah, based out in Dubai and supporting TikTok on a global level in regards to commercial guidance and laws. Before being at TikTok, I was previously at RPC, so Reynolds Porter Chamberlain in London. I was there for 6 years as a senior associate, and I've had secondments at Meta for nearly 2 years, and I was also at 3 Mobile. So have the best of both worlds in terms of private practice experience, but also that in-house as well, which has touched upon AI and IP rights and infringements throughout. So looking forward to talking about this very interesting topic, and looking forward to running through.
Yeah, there's a lot to go off with AI and IP. They're kind of obviously AI is at the forefront of absolutely everything at the moment, especially when you're looking at commercial awareness and IP and obviously how property rights are being protected. There's so much to get into. So, but for those that are new to commercial awareness, could you explain what's driving all of the current discussion about AI and intellectual property and why it's such a hot topic for businesses?
Yeah, of course. So intellectual property and intellectual property rights, because that's what everyone thinks of, rights and infringement of those rights. IP's been around for forever, it feels like. It's a very well-established topic and area of law, both in the UK and also further afield. And it's something that has been at the forefront of companies and your potential future clients' minds for some time. But the landscape of IP and the laws that surround it continue to shift, especially as emerging technologies, obviously AI being one of them, continues to develop. And the problem is new legal challenges continue to crop up for both lawyers who are advising on them and also for the businesses and the clients to navigate. So it's an ever-changing area of law because obviously it's AI focused, but it's quite strange because IP is quite entrenched in rights and it's quite specific. So the combination of ever-changing and well-established coming together is quite an interesting topic. And it's something that various businesses and lawyers as well at the same time are sort of having to grapple with. And also, I think IP in itself as well is just because the onus is on IP and IP rights that are attached to AI and AI-generated content. The combination between, and we've seen a real growth in IP and IP law. And actually, for example, amongst law firms in the UK, this is obviously UK specific only, just in regards to the statistic, but nearly 10% of all new partners are being promoted into IP, which is crazy. So that's 1 in 10 nearly of every partner that's being brought up at a UK law firm is going into IP. So it just shows you the focus on IP generally. And actually, part of that will be driven because of AI and its development and how AI and IP meet or do not meet. We'll see.
So it kind of in 2025, a lot of the attention's kind of around these two standards, one which is quite entrenched and obviously one that's so new and fresh, kind of pulling against each other.
Exactly that, Dan. Yeah, exactly that. And it's fascinating to see because it's almost like tearing up the rule book to a certain extent, because not starting from scratch, but actually developing these well-established principles and attributing it to technology which is ever growing. So, and ultimately, this will have a commercial knock-on effect to businesses.
So, to lead on to that, what are the commercial implications for businesses as governments are trying to balance innovation with updating legal frameworks?
Very good question, Dan. So ultimately, as we said, and we alluded to sort of at the beginning of this pod, it's an ever-changing space, but it's an ever-changing space for businesses and for lawyers, but also put the third one in as well, government. So governments are looking to introduce new laws and regulations around this, but also trying to keep up to date. Again, they've had a long-established rule book in regards to IP rules, rights, and infringement subsequently. But we see, and we can see now already, and we expect this to continue, especially as AI continues to evolve. The governments and regulatory bodies and so forth continue to sort of grapple with balancing strategy in regards to not stifling business and encouraging development of AI and innovation, and also investment into their local areas, so local regions or countries. But also at the same time attempting to sort of modernize those long established IP laws and frameworks that have been in place for some time to account for AI and the ever growing consumer wants and needs around AI. So we can look at the products and services that are being driven by AI and why consumers are using these all the time. But there is pressure on jurisdictions around the world. This is not just UK specific to address IP infringement, because AI has just blown up. And it's now everywhere, and it's the hot topic. So there really does need to be a onus on governments to take this seriously, but also engage with businesses to, as I said, to not stifle that innovation and growth. And we have seen that, and it's quite interesting to see the different approaches across the world. The UK versus EU, everyone keeps looking at, because obviously it's a bit closer to home, but actually further afield. But we have seen, even in some of those jurisdictions whereby there's maybe a little bit of reluctance to change from the standard status quo, especially in regards to AI, there are think tanks, there's collaboration, and we hope that continues from a legal's perspective, from a lawyer's perspective. It's really good to see, and it helps us advise, and you guys that are listening to this advise in the future, but also it really helps clients and businesses navigate this very tricky space, because ultimately it leads to more transparency around what's coming down the line, what is expected of businesses in this space, and where they stand. How do they protect their business? How do they protect their own IP, but continue to grow? And also subsequently, the issuance of guidance and FAQs and so forth really does help. So there is a commercial knock-on effect, as we said, but at the same time, it's quite a positive one so far.
Well, I guess that's one of the reasons why it's such a big space kind of to keep an eye on, I guess, because there's so many changes, and you've got so many different factors involved, in which obviously and it's kind of shaken up quite a lot of areas of law, not just IP law, but pretty much every area of commercial law and beyond is going to have some knock-on effect. So if you're able to follow along with this, then it puts you in a much better position to kind of look forward and see what's coming.
100%.
So as we move to the intermediate section, kind of one of the big things that is brought up around AI and IP are these things called NIL rights. So that's name, image, and likeness rights. Why are they becoming a bigger issue for influencers and athletes in the age of AI? I know we've covered the kind of influencers and stuff like that, but it's one of those changing spaces that's so big.
100%. And influencers are using AI all the time. So on TikTok, for example, on Meta platforms, on YouTube, they are really trying to build their own platforms and own portfolios by the use of AI. The use of AI actually to reach out to their own followers, but also to engage with brands or future brands that they want to work with or currently work with, including their products and or their services. So as you mentioned, Dan, so influencers and athletes, because there's a huge focus on AI-related products that are in the fitness industry. Actually, it's a booming business, and it's just a good example or prime example of how AI meets with a specific area, but actually to hone in. But as I said, influencers and athletes face new issues around name, image, and likeness, and their rights that are attributed to that. and content creation and everything that comes with that, and especially with AI-driven tools, because who owns the AI? Does the influencer subsequently own the creation that's been created by them, or does it the brand? And you can see here how brands and influencers, for example, third parties that businesses and clients engage with, are really trying to navigate this very difficult subject. But the days of a business or a client creating sort of content out there and so forth is not really a hobby anymore. It's a multi-billion business. And essentially, we talked about this on influencers influence on another pod, which we definitely recommend you to go and have a look at. But actually seeing how there's much of a focus on influencers and around this specific area, and how that tallies and is a concern in some instances for businesses around protecting their own AI, because influencers working with brands and businesses create content via AI, but actually who owns that content and how can they manage to own that content, or have distribution rights around said content? So it's definitely something to take into account for businesses, but also influencers. So when businesses are engaging with influencers, which many of us, many businesses do in this space. So that's just one issue. And then AI and copyright. So who owns the AI generated content, which I sort of alluded to a moment ago. But the question has and will continue to be central to sort of litigation rules and industries incorporating AI into their daily work. So, as I said, it's a really hot topic, and governments and industries are really trying to catch up with this, because at the moment there's no rules or regulations to a certain extent that really deep down address this issue. The UK has implemented some IP protection for computer generated works, but it's quite light touch at this moment, or in my opinion, it's quite light touch. It doesn't go to the full extent that is required to navigate this ever-changing area. And it'll be interesting to see how other countries that maybe are not so willing or maybe more reluctant to accept AI address this. But there is a real confidence, and I think we mentioned this in sort of the beginner section of this pod as well. There is a real confidence within the industry, within governments, that this is being taken seriously, and there's a positive spin on that. There's a real willingness to come together, collaborate to ensure that AI is not stifled, but also those intrinsic rights and ensuring that IP is protected remains the case. So that's just a little bit of flavor there, Dan, in terms of some of those key things that businesses and clients need to consider.
I guess kind of looking slightly away from the full commercial area, but one of the areas that AI and regulation is kind of at the forefront of is stuff like biotech and science and kind of the disputes around that. What's happening to those patents in those sorts of fields? And how's AI and regulation kind of dealing with those disputes?
Great question, Dan. So as I said, it's because it's such an ever-moving topic and space. Governments are still trying to catch up, and lawmakers are at the same time. So it's the balance of enforcing laws to a certain extent around this area, but all to protect businesses that have a long-standing position within the market. And as you said, in regards to sciences, patents, for example, it's basically the crux of a client's business, right? So if they don't have the strength of the patent and it's not standing within the legal framework, then actually arguably their business is gone, because that is their business, having that bit of paper that says this is ours, we're able to sell it. So, but actually the balance of ensuring that competitors, for example, so when a competitor enters quite a volatile market, has the ability to sort of like try and pressure the big giants of the tech space and the science space and so forth. So your big four per se in that area, and the use of AI to sort of catch up. So it's interesting to see how others are using AI to sort of try and level the playing field a little bit. So at the same time, lawmakers, although it's not their role, I think they're alive to the fact that actually this is a very, very difficult area to manage from a legal standpoint, compliance standpoint, and actually lenience will be given over the course of time to ensure that businesses, long or new, established, are not penalised for compliance in this area, because as I said, it's so fast moving, so fast paced, and the rule book has not really been written in regards to this.
I guess from the lawmaker's perspective, it's them ensuring that obviously these businesses are able to maintain and keep up, but also they don't want to stifle other areas. They've kind of got to make a balance between which, because in one way or another, any decision that's made is going to put some sort of stifling effect on either side. So it's kind of maintaining that balance, I guess.
100%. Yeah, completely agree, Dan.
Kind of looking onto the lawyer's side of things, how can commercial lawyers advise clients to protect their IP and manage risks as AI becomes more embedded in daily business?
Great question. I think, and this is a common theme that we've discussed on a number of pods really. I think it's being and remaining up to date with legal developments. So, and we've seen clients, so when we've been advising clients in this space in regards to sort of AI developments and how that potentially could impact IP. So let's take the IP point standalone first. It's really important that businesses and clients know where their IP stands, what it entails, what it looks like. And for example, where there's IP registrations, when they need to be updated, what they afford and allow the business to actually do, like the constraints around that IP, and what they're looking to do with that IP. So are they able to, or is there enough flexibility in their contractual structures internally? Because obviously, typically in these instances, we're talking about big businesses. We can also be talking about small businesses, but typically if you've got registered IP rights, for example, in the science space, many of these businesses are multi-global businesses with various different levels, and there could be the ability to sub-license within the same organization and so forth. So from a standpoint internally, just from a legal IP point of view, what is the IP? How is it protected? How long is it standard to be protected? And is there the ability and affordability to be able to sub-license within its own organization as a business and client? So that's first and foremost. And then secondly, when working with third parties, for example, typically the businesses in this space within organizations will work. When they're working with third parties, putting in robust contracts and agreements that set out clearly, very clearly, the IPs, the ability, and if IP rights, which typically are sub-licensed out, what that third party can do with them. So say, for example, is it a franchise agreement? So if you've got like a Subway model, for example, what is the ability? What's the constraints? It's very well established sub-license model whereby in a franchise agreement whereby shop fronts are able to display the Subway name, the logo, the look and the feel of the Subway wherever you walk into is pretty much the same. But it's because Subway in the organization is very good in terms of keeping consistency, the branding, the imagery, because it's continued to adopt and retain the same IP rights, and the distribution is exactly the same. There's no nuances between the sub-license of IP branding in the UK as opposed to countries in the EU. It feels very much the same. The products and the service is very much the same. Okay, the sourcing of the ingredients might be different, but actually it's the actual product and the servicing, so the IP around that. So robust contracts in place to afford people the ability to flex and move. And then the AI element. So when drafting that contract, you have the IP section. Typically, you have your IP clause and the constraints around that, but actually the integration of AI. So if AI is used by the owner, i.e. the client in question, that's their IP. But what if the sub-licensee goes off and creates additional content using the owner's IP, but AI, and merges the two together? One, does it have the right to merge the two? And separately, any content that's created out of that merge, who owns it? What does it look like? Is there a happy medium to be met? So all these commercial considerations need to be considered, obviously, first and foremost, discussed with third parties, and then also put into writing as to who owns what and in what scenario. So it's almost, you can see how much of an impossible task it is when IP meets AI, because when you're talking about content creation and the output element, who owns that? You're almost trying to look into a crystal ball to understand what potentially could come down further down the line. But it's your job or my job or a commercial lawyer's job to sit back, take a look and think about these considerations, advise clients in negotiations with third parties around these very difficult areas.
I guess it is kind of like the £1 million question is who owns this, especially when there's so many different parties involved. And I guess if lawyers can get in quite early and draft out and be very specific and intentional about who owns what in this circumstance, who owns this in this circumstance, then it saves a lot of time, effort, and dispute fees, I guess,
100%.
rather than having to leave it to chance. So we'll move to the advanced section, kind of looking a bit more into this. But how can businesses and their lawyers use contracts to address IP infringement risks with AI systems?
So liability is always an issue. As a commercial lawyer, you'll come across this in every single scenario. It's always one of those hot topics that's sort of eagerly debated in commercial negotiations, regardless of the product, service, or the deal that's made to be had. But liability for IP infringement has remained at the forefront of disputes going forward. So, and an AI system that's been integrated into long-standing IP has only added to that IP litigation. So there was a lot of IP litigation before AI, and actually it's only heightened that litigation, or not even the end result, but actually the contentious debate and commercial considerations that go into these commercial contracts and discussions. But many AI systems themselves, so we've talked about the owner of the IP, we've talked about the third parties that they work with them, but now in the advanced section, the AI system. So the AI system itself as well takes learnings off the content that's pumped into it. So if IP is being put into the actual AI system, we're not now talking about the third party, so your subway model. We're now talking about the actual AI system and the person who owns the AI on that content creation. Who owns the output? If we've managed to carve out from a legal standpoint the third party element, we now need to take into account the AI system and the person who owns the AI. And do they own the content? Do they own the learnings of it? What if that entails the original IP of the business or your client in question? So these are commercial considerations that need to be taken into account. And many AI systems, there's loads around now, Dan. It started off with ChatGPT and it's just gone crazy. But many AI systems seek to exclude or limit liability arising. They will pretty much just say, right, here's our platform. You're more than welcome to use it. But actually, any liability arising to output to your end users has nothing to do with us. And the issue of output, we keep saying output. I've said it a few times during this pod. Is the output may infringe the copyright of another company. So the output may infringe actually. So say, for example, we're talking about in the sports space, and if you're talking and you're Nike and you're putting out content through an AI system and you're working with a third party, but actually the output then mirrors something that Adidas has done, Adidas are going to quickly say, hang on a minute, you've pretty much copycatted something else that we had or another product or service that we offered. And then you're in a position whereby, is it the third party's fault in terms of the infringement of the AI of Adidas? Is it the AI system itself? Is the business who the AI tool who's provide the tooling, is it their fault or is it your fault? And actually that contractual conundrum of liability then starts, and we call it, it's chaos. It can be chaos. So when advising clients, it's really, really important that, and especially when clients are looking to use and enhance with the use of AI tools, is do your DD on the tools, make sure the tools are sufficient and adequate for your organization. It's not one rule for one and that's it, and that's the same. It can be different depending upon the company in question and what data you're looking to put into it, and are you willing to put your IP into it and take that risk. So navigating the risks, being aware of the risks, and trying to protect as much as possible at the forefront before getting in a position whereby you're in a dispute and you've copied someone else's IP and so forth.
What as a way to avoid this, what sort of tools or technologies are IP right holders and advisors starting to use to streamline their work and manage infringement risks?
So, sorry, say that again. Sorry, Dan, that last bit.
So what tools or technologies are IP rights holders and advisors starting to use to streamline their work and manage infringement risks? It's quite a big question, but
Great question. So in terms of tooling, I think ultimately business trends. So before it comes back to what we sort of touched upon at the beginning of this pod. So ultimately, what is your client trying to achieve by using AI? So first and foremost, what is the use case and what is the reason for that use case and what is the end goal? So the start and the end and work your way back, right? So this is the starting point. What is the output? What do you want that output to look like? And then working your way back. So there's going to be, typically there will be, if you're just dealing with the AI and the AI software itself, the output here, working its way back, what data needs to go in, what parameters need to be put in place. So the tooling, the technology that needs to be put in place in terms of internally. So making sure that certain data fields internally are not shared with the AI, putting in robust practices and procedures internally before basically providing very sensitive information. And this information can be quite sensitive. It's the retained business ownership that you're providing basically to an AI tooling. So carving out specific parameters that the AI can and can't do. These AI tools, and obviously we're talking generically here, but so it's a bit difficult. But obviously, if once you've done that DD, you've selected the AI that you're looking to use and help to enhance your business, looking at what it can do and what it can't do, and actually marrying them up, and then providing that AI with useful data sets to get to that outcome. Not just grabbing the AI and just pumping all of the business information in and its IP, and then just hoping for the best, but actually being very clear and concise internally before using these tools. So taking stance, putting in a robust practice and procedures to prevent infringement of alternative competitors and IP within the market, and having that strategy as to what you want as the outcome.
I guess.
So, technical tooling, essentially technical tooling. Yeah.
And I guess we'll kind of see as this progresses over the next few years how those sort of tools and such will kind of expand. But along that same line, what's your outlook for how this field will develop over the next few years?
Great question. I think ultimately it will continue to develop as it has. I think the rule book will probably catch up a little bit, but then I think we've said, 2 steps forward, 1 step back a little bit. I think that's just the way it is with AI ultimately at the moment. It's a very volatile space. And I think it's important that businesses, the businesses that it works with and collaborates with, but also the rights holders of IP and the AI tooling companies really work together to basically make sure that data is protected. I think ultimately that's the outcome, where we're in a position whereby actually the IP of another person, whether on an individual scale or also related to a business, needs to be protected. So a data element here, I know we're talking about IP, but a data point there as well. And then also ensuring that the AI tooling is being provided with the relevant information to not inadvertently or directly infringe upon another's IP rights. So making sure that actually those parameters scoped out well in advance. But ultimately, this space will be an ever-changing development. I think the early engagement with governments and think tanks and so forth continue to basically build on what's been built so far, because it's been really positive. I think we've sort of alluded to that earlier on. It's been really positive. But continuing that. But from a commercial lawyer's perspective, like bringing it back to obviously All About Law and students that are sort of logging in to watch this pod in regards to what it means for them. I think ultimately from a commercial lawyer's perspective, keeping up to date with those developments. I know it sounds so obvious, but really keeping up to date with developments, taking quite a holistic approach rather than just going, okay, here's a new law. What is it? This is the outcome. Actually, no. So taking a step back, looking at the potential business or client's perspective, looking at the AI developers' perspective, looking at third parties that might want to work with the client or the business. That could be an influencer. That could be another company collaborating. What does it mean for them? What does it mean contractually, legally between the two? And ensuring that there's flexibility, whether that be in commercial drafting, whether that be in relationships that are being built to afford flex because things will change. And if you sign up, for example, a framework agreement or a collaboration agreement for 2 years, I can guarantee you it would have changed so much since the date that it was become effective. So the ability to be able to change and adapt with AI, but ensuring those rights that are attributed to a client's business and their IP is upheld and protected.
And I guess from the first stat you gave us, where nearly 10% of all partners in the UK they've been ever promoted or moved across were in
Yeah.
IP, it does show that this is an industry to really keep an eye out on. That not only in the disputes section, but also in the initial drafting stage, and
Yeah.
kind of companies being really on it to try and avoid litigation risks, or to maybe push the boat out in certain instances. Yeah. It's going to be really interesting to see because obviously there's a lot of big players in this field and there's a lot of money behind it as well. So,
Precisely.
yeah, so seeing how businesses, law firms, governments all react around it is going to be huge over the next few years.
100%. 100% done.
Well, what's it? I think that rounds up our commercial awareness compass session. So thank you so much for joining us today, Brendan. And thank you for everyone else joining us today. So remember, being commercially aware isn't just about following the news. It's about understanding how these developments shape business decisions and legal strategies. Whether you're just starting out or thinking like a commercial advisor, always ask, how does this impact clients and what can a law firm do to help? Join us next week to keep building your commercial awareness. And until then, prepare without the panic. Thank you.